I'll be talking about free software and open source and what machine learning has to do with this. Now, there's a warning I have to make. The floor is wet and it's slippery because this is something I'm conceptualizing at the moment, and hopefully something that will end in research proposal for my doctoral thesis. But what I want to cover here perhaps today is why free and open source licensing matters to machine learning, and how to make sense of it, and also whether it still makes sense in a way. And usually I would start this talk with a functional decomposition of machine learning that I particularly like, and that I think serves the analytical purposes of lawyers quite fine. In the interest of time, I will condense this a bit. So saying this taxonomy that you see here is the product of machine learning policy developed by a Debian developer for the purposes of the Debian project. It's not officially endorsed by the project. But the taxonomy, in my way, shows lawyers especially very clearly the specific artifacts that we are interested in when it comes to machine learning. So the first artifact is the so-called human readable source, which includes the source code. So this is the typical application we're talking about, written in a programming language, C++, Python, Rust, whatever. And this source code is usually used for model creation, modification, inference, or analysis. The second part of this human readable source component is the data, of course, in the colloquial sense of the word, meaning digits, text, images, audio, video, and so on. And these data we use to train, validate, and test the model in the cases of supervised and supervised learning, or environmental simulators, which we use for the purpose of reinforcement learning, Then the second component in this taxonomy is the so-called serialized model, which is probably where the most interest lies. And this is indeed the machine learning model, serialized in any format. That could be binary protobuffer, could be JSON, could be a Python pickle. Simply put, serialization is the process of translating a data structure or object state into a format that can be stored or transmitted and reconstructed later, which is the difficult part here often. And then the generated artifacts, the third component, which are the actual objects produced from machine learning models. So these could be whether with or without external inputs given as hints. So this is when we talk about auto-generated articles, images, video, sounds, and so on. So each of these three categories of artifacts, I think, could be said to have certain economic value and may, under certain circumstances, be considered protected works under copyright law and concurrent protection, as we already heard from Jean-Marc and Thomas, under other IP and non-IP based regimes. So think of pre-trained models and then their increasing economic value for transfer learning, for example. Now, you may be wondering, why does it make sense to talk about FOSS in all this? Well, because FOSS has been established as a commercially viable model for now more than 20 years. Even Microsoft jumped on this bandwagon, which was quite a thing. And when they did this, the victory was pronounced. Peace broke out. Open source was considered well and universally accepted, meaning it can generate value besides the pure need to hide your source code, which was the traditional practice in proprietary models. So in copyleft-based reciprocal licenses, companies typically generate revenue from professional services and not from license fees. In contrast, permissive licenses, as many of you know, BSD, MIT, so-called academic licenses, they allow companies to generate revenue from both licensing and professional services. And this is how usually the so-called dual business models emerge, where you have a proprietary version of a software and a community version. And the difference is that the proprietary version is licensed under a license that does not contain the so-called viral clause, meaning if you as a licensee want to make something new in the software, you can then license it to someone else and you don't need to share the modifications with the community. Now, why do companies choose to go open source? I really like this approach taken by prominent FOSS lawyer Amanda Brock, who says that whenever a client approaches her, she usually attacks them with 3 what-if questions. And these are what happens if you create something core to your business and you open source it, and someone comes along, takes it, and makes it their own product? What if they make money, a lot of money out of it, and what if they make a lot more money than you do out of it? And she says, if you can't respond meaningfully to all these questions, that means that your business model is probably not well suited for an open source software licensing. Then the problem, of course, with machine learning and more generally with so-called cloud native software now is that the distribution model of software has changed. So companies now choose FOSS for many different reasons. But the big problem here is that we very rarely see software being shipped directly to customers. We are usually talking about proprietary models that are accessible via APIs. And this is, of course, also the case for machine learning. The famous or infamous GPT-3 is only available through a private API with a waitlist on top of that. And that brings me to what FOSS is and why it matters here. Well, I guess you all know that FOSS is considered probably the biggest hack on copyright, because what it does is take the notion of property and turn it from an instrument of control and limitation into an instrument for sharing and collaboration, which is really the essence of free and open source software. And this pyramid here that you see, this triangle with three angles, the author, the intermediary, and the user are what form essentially the collaborative model of open source. Because don't get me wrong, open source is by no means chaotic. I mean, communities usually have intermediaries that govern the relationships that emerge among them. And these intermediaries could be a company like Red Hat, could be Google, or could be organization emerged on the basis of community collaboration, such as is the case for the Debian project, for example. And these contributions are usually governed by so-called contributor license agreements. And in the core of these collaborations, what is really there is still property. So in this sense, open source is not to be taken as doing away with copyright. In fact, it depends heavily on copyright, because the trigger for any copyleft provision is indeed the original copyright that exists in the world. But now, just giving access to the source has recently proven insufficient, really, with the shift to cloud-native applications that are offered as services. The preferred mode of protection in these new scenarios, you will see it's trade secrets. Yet, copyright still remains applicable nonetheless, and it represents a challenge in the sense that all existing FOSS licenses that we have depend on copyright arising in works. And in the new AI regulation also, if you read how AI is defined, it says outright that it's software. But the question here is, would copyright law apply just the same to this particular type of software? And also, what does it mean to license machine learning software? And what is it that is being licensed precisely, and how would a FOSS license apply to machine learning software operate in these settings? And now to a bit demystify some of the dichotomies that exist in copyright law, I will give you a provocation here with trying to break down some of the dichotomies that have been well established, I would say, in copyright law, but it may not always hold on too much if you push them too hard, as James Grimmelman says. So the first one is the distinction between source code and object code. You know, the typical scenario where the source code and object code dichotomy holds is this: the programmer writes code in a textual form, this is the source code, and this code is then translated by a program called a compiler into another form, object code, which can then be executed directly by the computer. This is clear. And in this case, the code is distributed in object form. So source code is human readable but cannot be executed directly. Object code is not human readable but can be executed by a computer. Much information is lost in this translation process from source to object code, so the object code cannot be used to reconstruct fully the original source code. The problem is that this typical scenario is hardly typical anymore, and this was something that Ed Felden noted in 2002, and now it's 2022 almost. things are dramatically different. Two examples. First is JavaScript, the very famous scripting language. So you write a source code, but then instead of translating this code into object code, the code is fed into a program that we call interpreter. And this is the spider monkey, a JavaScript engine in your Firefox browsers, which would carry out the code's instruction. And that code never gets translated into object code. So there is really no object code. The second example is that object code itself can be translated into additional forms before being actually executed by your CPU. So the Intel Core i3, 5, or 7 CPUs that you all have in your notebooks to access this conference gets the object code and translates it into so-called micro operations, which are, shortly put, detailed low-level instructions used in some designs to implement complex machine instructions. The problem is that these micro operations perform basic operations, and they are subject, so the object code is subject to translation into such micro operations. So there is an additional step that is nowhere to be seen in these dichotomies. So my point here is to say that assumptions in copyright law do not always hold up, and object code is not the only form of source code that can be executed. Source code can sometimes be executed without an intervening translation to object code. Executable code can be human readable, and so on and so forth. So similarly, arguments can be put as to the distinction between program and data. There was a famous case in the US, so some of you may know it, the Capitol Records versus Redigi case. And the case concerned a company, Redigi, which was engaged in the seemingly oxymoronic business of pre-owned digital music sales, a set of case law that has also counterpart in the EU. But essentially what it was letting was its customers to sell their music files to each other. And Redigi argued that what it was doing was protected by the first sale doctrine of exhaustion, and so on. Just as with physical CDs, resale of legally purchased copies is legal. The Capitol's counter in this case was that no physical copy changes hands when Redigi user uploads a file and another user downloads it. And importantly, and this is the curious aspect here, in Redigi's view, the MP3 files that its users download from iTunes and then sell through Redigi are actually computer programs that qualify for this defense. And the response of Capitol in the case was, well, in the ontology of the US Copyright Act, MP3s are just data, sound recordings to be precise, they're not programs. But if you look at this distinction, this dichotomy from a computer science perspective, you would see that already in 1936, it was Alan Turing himself who convincingly proved that there is no really difference between program and data. He showed that any computer program can be treated as the data input to another program. And we could think of an MP3 as a bunch of data that is used as an input to a music player, or we could think of an MP3 as a program that, when run correctly, would produce sound as the output. And both truths would be correct. So in this sense, what I mean to say here is that the extent to which copyright law distinguishes a program from any other information stored in a computer, at least in the von Neumann model, which our computing currently operates predominantly, means that it rests on a distinction that collapses if you push too much on it. So in this sense, getting back to the question of machine learning, would the serialized model that I mentioned be data or program? I'm putting this here and will not discuss any further because we don't have the time. Now, the shift to the cloud changed a lot of things for FOSS licensing, because what we saw in response to the cloud was the adoption of the so-called Affero GPL v3 license in 2007. But the problem with this license is that it only required disclosure of source code for users interacting remotely with this piece of software upon implementing a modified version. So when a version is running on the server side and it's licensed under AGPL v3, and you've modified the program, then you need to provide meaningful way for the users to interact, to get the source code of the program. AGPL v3 was really not well adopted, or at least not widely spread adopted. So all in all, one could probably say that it's definitely not successful. At least that's the majority of views in the FOSS community. But then the question that arises here in the context of machine learning is whether code is still the only useful artifact when it comes to FOSS. Because the monetary value of most software is inherent to the source code itself. Even for large and important code bases like Linux, once you have access to the source code, it's relatively trivial really to move from source code to the valuable end product, which is the binary executable. So access to the source code and granting freedoms around it, which copyleft does, for example, has taken primacy in licensing for most general purpose software. That was until the cloud came. Machine learning is even more striking, because here source acts only as a sort of a framework, wrapper around the training for the correct weights we are looking for, which is the actual valuable artifact, as Jean-Marc pointed. And finding these weights for the GPT-3, for example, was estimated to cost $4.6 million. So the pre-trained versions of the most common architectures are downloaded and fine-tuned, reducing cost. This is where transfer learning kicks in. So the argument goes, unlike most other software, the marginal cost of production for useful machine learning software would rarely be close to zero. And in this case, the trained model's copyright is not the default inherited from the license of the code that trained the model, which is crucial for the way FOSS licenses would operate around this. So the human readable source may be licensed under GPL v3, but does that mean that the serialized model would inherit this license? And then the second problem of data that was already addressed by both Thomas and Jean-Marc, it also brings forward the questions of the dichotomies that copyright law operates. I share the views of some developers that getting cloud native licensing around network access rights is crucial for the future of machine learning applications, which would be essentially undisclosed machine learning systems behind the APIs. Make no mistake about this. We are getting back to the age of proprietary software closed behind very well guarded walls. And GPT-3, for example, is not publicly available, as I mentioned, only accessible through an open API with a waitlist. Now, why is that, you may wonder? The arguments of OpenAI to do this were the following. So they said, we need to commercialize the technology, and it helps us to pay for ongoing AI research, safety, and policy efforts. That's a valid argument. Then they said many of the models underlying the API are very large, taking a lot of expertise to develop and deploy, and it makes them very expensive to run. So it's better to count on us to run them for you, is basically their argument here. And thirdly, the API model, they say, allows them to more easily respond to misuse of technology. Since it's hard to predict the downstream use cases of their models, they feel that it's just safer to give access to them through an API rather than open source the model. Now, whether that's the right approach, I cannot tell. But what I can tell you, and I'm going to conclude with this, is that the FOSS governance for the future does seem bleak indeed, because for those of you who are familiar with the recent developments around Amazon Web Services, the relicensing of MongoDB, the server-side public license, all of these developments go to show that we try to hack again free and open source licenses by introducing elements such as in the server-side public license requirement. If you are a cloud business operating an open source application on your infrastructure, a requirement to disclose not just the source code of the program you're running, but also the underlying service stack. So this is, and here it says, without limitation, management software, user interfaces, APIs, automation software, monitoring software, backup software, storage software, and so on and so forth. Among the FOSS community, there is a common agreement that this is not a FOSS license, simply because it first discriminates, which is against the sixth principle of the open source definition, but second, because it's simply not compliant, not compatible with the FOSS culture and the FOSS policy objectives that we have. And this is something the Open Source Initiative highlighted prominently in their statement that the SSPL is not an open source license. So in a way, companies, small companies try to hack again FOSS with a view to securing profits for their business models, which again, I would agree that companies such as Amazon indeed deploy this widely and offer it to customers without actually, in some cases, contributing much back to the community. That's of course not always the case. But the thing is that open source allows this, and we cannot extend and we cannot expand the scope of copyleft, for example, beyond some reasonable limits, which are anyway established in the licenses. So, in other words, you cannot use licensing as a way to deal with anti-competitive behavior on the part of big tech companies. That's not the way to go. Now the problem is, what is the way to go, and what is the future for free and open source licensing of machine learning software? And the research questions that I'm pondering is indeed, how do the building blocks of machine learning fit under the framework of copyright law? How many of the dichotomies that we have operated by copyright law can withstand the push of machine learning software, such as the two examples I gave you? And there are many other examples of doctrines that may not easily withstand deeper push. And then what is the scope of copyleft, the so-called colloquial, esoterical, maybe even corresponding source when licensing machine learning software? And what would be the role of reproducibility to determine this scope? So when would the requirement to be able to go back from the binary to the source be met when it comes to machine learning, for example? How should network access licensing be dealt with to advance these policy objectives that we pursue with FOSS? And is license proliferation, because some suggest, okay, we need to adopt a new set of licenses, and that's how the responsible AI license, cryptographic autonomy license, the SSPL and others emerged. But is that not a threat to the future of FOSS? Because we don't want to end in a situation where we're awesome, yet we're closed. Thank you very much. I'm afraid we won't have time for questions, but please feel free to reach out to me on any of these questions with feedback or ideas or comments. I'm very much